that again then. What up, family? Welcome back to Flesh of the Gods for the second time. Today we will be covering Adam Coy for the murder of Andre Hill. I was recording it, about to make some edits and stuff, but I figured, hey, why not tap in and watch it live with the family? So either way, I appreciate y'all for being here. For those who coming in, and I appreciate y'all for not being here. For those who ain't here yet, shout out to the replay crew. Appreciate all y'all. Show some love for everybody. We about to get it started.
Welcome to Flesh of the God.
Thank you, Your Honor.
Well,
Renee Amlin on behalf of the
Isn't
state of
this
Ohio.
a nice surprise?
Good morning, Your Honor. May it please the court, I am Mark Collins, 006-1207,
And I'm Caitlin Stevens, 0095589.
both on behalf of Adam Coy, who was in the middle of us, Your Honor.
All right, thank you. Okay, this matter is scheduled for sentencing today on behalf of the state.
Thank you, Your Honor. As the court is aware, a jury convicted former officer Adam Coy of murder, felonious assault, and reckless homicide back on November 4th of 2024 after approximately 2.5 days of deliberation. Mr. Coy was convicted for shooting Andre Hill 4 times and killing him in a garage on Oberlin Drive on December 22nd, 2020. After hearing all the evidence, the jury determined that in light of the facts and circumstances, that Mr. Coy's actions in using deadly force to shoot an unarmed man were not justified and were not what a reasonable officer would do. The events that occurred that night and during the early morning hours of December 22nd, 2020 are tragic. All the way around, the events were tragic. For all of the people who were involved and/or all of the people who were affected by the events that occurred that night, it can likely be said that those were some of the worst nights of their lives. There is only one sentence for the court to impose here, and that is a sentence of 15 years to life for the murder conviction in count 1. It's the state's position that the other 2 counts were essentially backup charges and they would merge with count 1, the murder. So the state elects to proceed on count 1 and ask the court to impose the required sentence of 15 years to life.
Hey, what up, Brown Sugar Babe? Appreciate you joining. And so, for everybody coming in, what I'm gonna do is I'm gonna do this one a little different because they just sentenced him today or yesterday. This was the sentencing. So we're gonna start with the sentencing, and then I'm gonna do the opening statements after that, and then we'll continue from there. But appreciate y'all being here. Hit the like on your way in. Let's go.
As part of that sentence, there is also a registration requirement for Mr. Coy to register as a violent offender. It's the state's understanding that that form has been completed as well. The state has calculated jail time credit in the amount of 274 days. There are several people present in the courtroom who would like to speak on behalf of Mr. Hill, and the state would like to present those people at the appropriate time.
Okay, now would be the appropriate time.
Thank you.
If you would please just state your name for the record.
Shauna Barnett.
Thank you, Ms. Barnett.
Okay, so I have 2 statements here. I have my sister's statement and I have mine. She's not here today.
Okay.
All right.
Just speak into the mic if you could.
Right here?
Thank you. Yes.
Okay. First one's Michelle. I am Michelle, Andre Hill's sister, affectionately known as Baby Sis. My brother Andre was stolen from his family. He leaves behind sisters, brothers, a daughter, 3 grandchildren who affectionately called him Big Daddy, aunts, uncles, nieces, nephews, cousins, and many friends who loved him dearly. My brother was such a friendly man. He never met a stranger. He was a gentle soul who loved his family and friends wholeheartedly. The last time I saw my brother alive was at our sister's wedding. I remember us gathering together prior to the wedding to go over how everything should go. I remember Andre being so happy for this joyous occasion and super proud about how he was able to walk her down the aisle. He had to look his best for our sister. He proudly pulled out his suit that he was going to wear along with all the accessories that was going to go along with it. all the way down to the shoes. The next day, seeing him walk her down the aisle to give her away, he had the biggest smile I had ever seen on his face. He was such a proud brother, and it showed. He didn't stop smiling and laughing the whole day. I still remember the smiles and the emotions he impressed on everyone that day. The next time I saw my brother, he was lying in a coffin at a funeral home with no family, with no life in him. I didn't get to see his twinkling eyes, which were always full of joy and laughter. I couldn't hear him say, "Hey, sis," or "Love you, sis," which he expressed anytime we saw or spoke to one another. On December 22nd, 2020, I would learn that my brother Andre was shot and killed by a Columbus police officer. Later, I would see the video of the shooting happening. The moans that I heard coming from my brother sent me into instant hurt. You see, what I also saw were police officers stepping over my brother as he lay on the cold December ground face down for minutes. I didn't see anyone consoling him. I didn't see anyone rendering any aid to my brother. I can't imagine the fear and shock he had about what had just happened. Seeing the video of what has happened to him has caused an enormous fear to police officers for me, because police officers are supposed to protect and serve the citizens. I go into an instant panic attack anytime a police officer is anywhere near me in an everyday setting. Losing Andre has deeply impacted our family. It's hard every May 23rd not to pick up the phone to call and wish him a happy birthday. It's hard not hearing the goofy messages that he would send to me to say that he was thinking about me. It's hard not hearing him call me and tell me about what the grandkids were doing and how you could hear in his voice how they brightened his day. He absolutely loved being a big daddy. It hurts to know that he will physically miss holidays, birthdays, weddings, etc., and the grandbabies. It's hard not hearing him talk about my boys and him telling me what a great job me and my husband have done with them. It's hard not hearing that he's proud of me. Even though I didn't get to see him as often since I live in a different state, he has always been one of my biggest supporters. It's hard knowing that he won't be with the family, cooking, laughing, and entertaining as he always has done during the holidays and other events in our lives. The time from Andre's death until now has been long and agonizing for us. My brother gave us so much to remember, and he will never be forgotten by us. Michelle Hairston, Andre Hill's sister.
Thank you.
Long live Andre Hill, shot down by Ohio police officer Adam Coy. What up, Miss DB? What up, Tia C? What up, Allie? I see y'all. Appreciate y'all joining. Let's keep it rolling. Now for her second statement from herself. That was her sister's statement. Now she gonna read hers.
Okay, so this is mine. My name is Dr. Shauna Barnett, and I'm here today not only as Andre Hill's sister, but as a representative of a family forever changed and by an irreversible act of violence. Andre was not just a name or a headline. Andre was not just my brother. He was the heart of our family. He was thoughtful, loving, funny, and full of life. He was a son, a father, a brother, a man deeply loved by all who truly knew him. He was the kind of person who made people feel seen and safe. His presence meant something. To me, he was my brother. To our family, he was a source of joy, laughter, and strength. And now his absence means everything. His life was taken in the most brutal and unjust way, without warning, without cause, and without mercy. There was no explanation, no justification, just a sudden, violent silence where his voice once was. He died alone, unarmed, and undeserving of what happened to him. And every day since has been marked by grief and disbelief. And from that moment forward, nothing has been the same. Our lives are split into before and after, and we are left with the pain that does not fade. We do not get a second chance. We do not get to rewind time or bring him back. We grieve not only the man we loved, but all the moments that were stolen from us, the birthdays, the holidays, the conversations, the simple joy of being in the same room together. There is no repair, no reversal. The impact of Adam Coy's actions is permanent. My brother's life was taken in the most extreme way, without cause, without humanity, without mercy. What Adam Coy did to my brother was the maximum, and the consequences of that choice, his death, can never be undone. This is why today we're asking for the maximum sentence, because Coy made a decision that delivered the maximum pain, because the weight of what was done deserves the full weight of justice. And just as that cannot be undone, the sentence handed down today should reflect the gravity of what can never be reversed. This is not about vengeance or revenge. It's about accountability, about dignity, about honoring the value of Andre Hill's life, and the unimaginable pain left in the wake of his death, and making sure this court sees the full weight of that life that was taken. We carry this pain every day, and we ask you to see us, to hear us, and to deliver a sentence that reflects the gravity of what has been taken from us forever. Thank you.
And so, real quick, for those who don't know about the enchantment points, that's the ICM coins, enchantment coins. Those are coins you collect by chatting. They build up by chatting. And I used to have a bunch of prompts popping up that you can alter the stream with by using the points. But right now, they kind of on the back burner because they was mostly just a bunch of YSL stuff. So I want to make some changes to it and make it where y'all can interact with each other with the points. I just had to find some time to do it. I ain't been able to get around to it, but appreciate you. And if you want to check your points, it's apostrophe ICM. Just apostrophe ICM.
Thank you very
No
much.
spaces.
Again, for the record, if you please just state your name.
Hi, Your Honor. My name is Michelle Stewart.
Yes,
I
ma'am.
am Andre Hill's former spouse. We met when we were 14 years old, went to school together, went to college together, and we had our perfect princess, Carissa Hill. She is the apple of my eye. She was his heart and soul, and our babies. Three little Ks is what we call them, K times 3. Those babies meant the world to him. Dre and I kept in constant communication because although Carissa was a grown adult, we always said we still have to raise her. You know, I'm in my 40s, my mom and dad still raised me. He was there for everything. The last time I spoke with Andre was 3 days before he was murdered. We would always go in half, like to buy the grandkids, you know, like a big toy, or I think that year it was like an Xbox, the little handheld one, and then get Carissa a purse or something. I was able to get 2 of those items. Dre's former boss was able to get the other 2 because Dre wasn't there, because he was murdered that night. Dre was such a caring man. He was a gentle giant. He was a beautiful man. He would literally, we were on our way home one night and there was a gentleman walking down the street and he was going like this. Dre did a circle, took off his coat and gave it to the man out, handed it to him out the window. We used to work at a restaurant, a wing restaurant in Whitehall years ago. There was a homeless woman with a little child that stayed in the back. Dre, we'd get one meal. Dre would give her that meal. That's just who he was. He would give you anything, and he was just gone too soon. And to have to explain to my grandkids, is Big Daddy getting up off the ground, Nana? Why is Big Daddy still laying on the ground after he was shot? Now we can finally have a little closure and we can explain to our grandkids, now that they're getting older, what happened. There's been numerous occasions, Your Honor, where I've had to get my daughter up off the floor. She's bald, curled up into a ball of depression and just what happened. She was Daddy's little girl. Nobody can ever replace that. And Your Honor, also, and his sister Shauna, she really summed it up for the whole family. I do want to also let you know that we still have faith in the police and our justice system. I live in Gahanna, Ohio. Officer Brown, Officer Cameron, I know all of them. They're very friendly. We still count on the police. I don't have panic attacks when I see the police. If someone looks at me sideways, that's the first thing I'm going to do is call the police. I know women who have beaten their children, men who have murdered their wives. We don't hate men and women. We don't hate the police, Carissa and I, and our grandkids. We don't hate them. Hate is a strong word, but we hate. Adam. And our heart breaks for his family.
Yeah, we hate Adam though. We hate that one.
His wife and his children. They were at home sleeping, as were we. So, thank you, Your Honor, for allowing me the time. We didn't write anything down because it wasn't rehearsed. It was just what came out. Dre was a beautiful man, and he loved them babies, and Carissa was his everything.
All right, thank you.
Thank you,
very
Your
much.
Honor.
Your name and who you are, okay?
My name's Carissa Hill, and I'm Andre Hill's daughter. You think you have something to say? I got 5 years worth of stuff to say. I don't even know where to start. I do have 3 children. Their big daddy came home to them every day to explain to them that a police officer took their big daddy away, that he's the reason their big daddy's not here with us no more. It's the hardest thing to do because those are the people that they tell us to rely on. If something happens, you're supposed to call the police. And that night, someone thought they was doing the right thing and they called the police, and now my dad's not here anymore. Rather this man gets a life sentence, 15 years, 20 years, it will not change the fact or bring him back. These 5 years, he not only took my dad away, but he took me away. I am no longer able to do the things I was able to do with my dad here. I don't feel safe in Ohio. I don't feel safe around Ohio police officers. And it's very hard to explain to my kids how we're able to trust the police, but they're the same persons that took the person that we all loved away. I didn't just call him my father, I called him my Faja. And I was his Daja, and I was his only child, and my kids are his only grandchildren. When you walk out healthy one day and then you just never come back, it's just very hard to explain to the kids, and even to myself, I don't understand half the time what happened. And what's even worse is sometimes they have it on video, so it's a reminder of how he ended his last couple minutes here on this earth and how he was alone on the cold floor. I just wanted to be there for him. I didn't even know till the next morning. The news channel found out before me. They actually was calling my phone and was asking, where's my dad? And I didn't even know where my dad was. I was calling every hospital in Columbus trying to figure out what happened to my dad. He's never had bad encounters with the police. He's not a harmful man. Everybody that knows him loves him. He doesn't bring conflict. He was just such a lovely man. And once again, I have 5 years worth of stuff I want to say. I just don't even know where to start because he's not here with me. And I'm just here to try to be his voice since he's not here. So one mistake by one bad officer, it changed a lot of lives. I'm sure it changed lives of his family as well, but I just don't even know what else to say. Okay. I do thank you for hearing us and for bringing justice. I was very scared that that wouldn't even happen since that rarely happens in these type of cases with officers. So I just want to thank the jury for seeing everything out and seeing the case for what it was and finally bringing this to some type of end for us. Thank you.
Thank you. Okay, anything else on behalf of the state?
Not at this time, Your Honor.
On behalf of Mr. Court?
Thank you, Your Honor. May it please the court, I think we're going to break it up in different compartments. First and foremost, my heart goes out to the Hill family. Your loss is unimaginable. The empathy that you show here, I can't tell you, I know how it feels because I haven't been in there, but my heart goes out to you. I'd also like to thank you guys for your civility and respect for the process. during this entire time, and I appreciate that. And to the Coy family and the law enforcement, my heart goes out to you. You guys are in an impossible situation many times at your job, but again, the civility and the respect for the judicial process, the court process, I thank you for that and for both sides. Your Honor, Ms. Coy would be first, but she would take about two words, Your Honor, and then she would start crying.
I do also have the body cam footage, so if y'all get antsy, then let me know. But I'll probably play it after this one is done, or I might cut it in between and play some of the body cam footage of the incident.
Crying, so Ms. Stevens is going to read her statement with the court's permission.
Yes.
Thank you, Your Honor. Trying to sum up who my husband Adam is into words is not an easy task. Duty, service, honor, integrity, truth, and justice are the words that most easily describe Adam, both personally and professionally. Adam served in the U.S. Army when he joined the early entry program at 17 years old and left 2 days after he and I graduated from the same high school in 1995. He's a decorated
Officer
veteran,
Amy
receiving
Detweiler.
multiple awards and commendations, and worked his way up to a sergeant, as well as training officer during his time serving our country. In 2000, Adam came home from the Army and started working at the Delaware County Jail while going through all the phases of the lengthy application process for the Columbus Police Department. During his 19 and a half years on the force, he received many compliments, medals, and awards, and that is who my husband is. Adam and I got married in 2002 and have 3 wonderful sons who are in the courtroom today. We taught them the same morals and values that we so strongly believe in: honesty, loyalty, hard work, and the importance of family. Speaking of family, when we were in our first years of marriage, we took in both of my younger sisters, who are also here today. We always stood as a safe space and home for them. We were actually raising teenagers while starting our own family. Adam, as a husband, father, son, brother, uncle, and friend, has always been our rock. He's the person people come to for help, giving advice and guidance, as well as being the person to provide help for anyone at any time. When he was diagnosed with cancer, Adam was determined to fight, even while being wrongly indicted for a crime he didn't commit. And after over 26 rounds of chemo, 2 stem cell transplants, including 2 30-day stays at the James and full body radiation, he's still continuing to heal and fight to win his battle with cancer and this wrongful conviction. Adam is my soulmate, and we have been together every day for the last 25 years. When I was diagnosed with SLE lupus, an incurable disease that attacks all of your organs, he went to every doctor and every specialist appointment with me. He sat through my monthly IV infusions, and he was always there to help take care of me, until November 4th, when he was convicted of crimes for which he did not commit. As a police officer's wife, you live your life with the knowledge and pit in your stomach that one day he may not come home. But never in a million years did I think
Y'all see that? He was there like 5 seconds, not even 5 seconds before he shot the dude. But
I would
but
lose
turns
him
out he was there
to a
before
conviction
that too.
when he
We
was
gonna get into that.
unfortunate.
My bad. Turns out he was there before that also, but when he came up that time, he was there 5 seconds, not even 5 seconds before he shot the dude.
enough to be doing his job on duty. He is the foundation of our family, and without that foundation, I'm very afraid for what our family's future holds. However, through all of this, we as a family, because of the lessons that Adam has taught us all, we know that the jury got it completely wrong, and in this case, we will continue to fight, just like Adam has taught us, and appeal this case to the highest courts to get him what we all believe, and that is truth and justice. Thank you, Your Honor.
Thank you.
Mr. Coy would like to give a statement at this point, Your Honor, and then I'll make the legal arguments after that.
All right, thank you.
My entire life, I wanted to serve. In my junior year of high school, I signed a 5-year contract with the United States Army. Then 2 days after graduation, I reported to Fort McClellan, Alabama, for training in the Military Police Corps. I served both stateside and overseas, rising to the rank of sergeant, receiving numerous medals and ribbons performing my duty. After being honorably discharged, I returned to Ohio seeking a career in law enforcement, first as a deputy and then as a police officer. again receiving ribbons and medals for my service. For nearly 2.5 decades, I responded to thousands of runs where it was my job to establish order from whatever chaos prompted the call. I was trained and conditioned multiple times each and every year. I also paid for and attended additional non-mandatory training on my own through the Ohio Peace Officer Training Academy. In those trainings, I was taught to respond to a threat without hesitation, because action beats reaction. On the night in question,
Then after 5 minutes after he shot him, 5 to 7 minutes of him laying on the floor, gasping for his breath, with them giving him no type of treatment, they decide to put him in handcuffs.
did just that. I saw what I believed was a silver snub-nosed revolver rising up to me. I yelled, "Gun!" "He has a gun," to my partner, so she knew what I saw, as we are trained. And I reacted the same way I had in hundreds of training scenarios. I drew and fired my weapon to stop a threat, to protect myself and my partner. I believe in the law.
Hold on.
That is why I dedicated my entire adult life to it.
Hold the fudge on. Did he just say hundreds of times? He been in hundreds of shootings like this? How, Sway? How is you still here? How is you even on the force if you've been in hundreds of shootings? How did that even make sense? All right, let's get back to it. That's crazy. Hold on, let me rewind that a little bit.
I drew and fired my weapon to stop a threat, to protect myself and my partner. I believe in the law. That is why I dedicated my entire adult life to it. I feel my actions were justified and within the reasonable officer condition and the standard as set forth by case law. I disagree with the jury's decision because I believe they did not understand the response a police officer is trained to perform as it relates to the Ohio Revised Code, relative case law, and they were confused by the jury instructions they received and deliberated by. So because of that, I will be appealing the ruling, not just for myself, but for
I guess I didn't go back far enough because I didn't hear it that time, but I know that's what he said hundreds of times.
everyone in the law enforcement community doing a complicated, dangerous, ever-changing job in a world of policing. This decision in this case has far-reaching effects on the police departments of this great nation. With that said, I would like to thank my family for their support with my long battle with cancer that coincided with this process, of which I am still recovering and continued treatment. And additionally, I would like to express my overwhelming gratitude to my friends, brothers and sisters wearing the badge for their continued support and encouragement to stay strong and have faith in our judicial system. This case and my actions have affected both sides of this courtroom. It weighs on me heavily that a family lost a loved one. My heart goes out to them. Thank you all for listening to me today, and your mindful consideration is deeply appreciated.
Thank you.
Shit.
May I proceed, Your Honor?
Talk about my actions was justified. Oh, according, yeah, they like all the other cops do it. How come I didn't get away with it? Everybody else get away with it. What up, No One? I see you. Appreciate you joining, family. No One said monkish shit. Sound like a bunch of monkish shit.
You may.
Thank you. First, Your Honor, just some procedural aspects. We did have him sign the notice form. With regards to some things that we must put on the record, Your Honor, before the appellate process, I'll just walk through those first. Number one, Your Honor, we would ask that you set aside all the verdicts in this case and grant a Rule 29 motion despite the jury's verdicts. I'll go into the arguments in a little bit. Second, Your Honor, there's 274 days of jail time credit, I believe, the government, and we agree to that. Third, Your Honor, we are asking for a bond after you put the sentence, Your Honor. We're asking for an appellate bond for several reasons. The first group of reasons, Your Honor, is that this is a case of first impression. What do I mean by that? Our Court of Appeals has not had a case with involved an officer shooting that goes up through it here in Franklin County. The Supreme Court has very little documentation on that as well. The second thing, Your Honor, is in that same concept is there is no OJI. And for the record, Ohio jury instructions. That's what OGI means. And in terms of that, Your Honor, jury instructions are formulated, they're tested, they go through committees, they go through judicial screenings, they go through legislative screenings. And those jury instructions are fine-tuned, and they evolve as society evolves, and they evolve as crimes evolve, and they evolve as deliberations. We learn things from the jury instructions, how to change them and how to make them better. As the court knows, there are no jury instructions in this type of situation. We create those from federal case law. We create those from state case law. We create them from the facts. And so those are difficult things to do, Your Honor. So we believe that one of the reasons for our request for bond is just that this is such a unknown area in terms of appellate issues. There are multiple appellate issues to be examined in this case alone. The court already dealt with one. However, the Court of Appeals will determine that as well, the alleged Brady violation. What jury instructions, what the experts were allowed to opine on, those are all things that will go into factor. The second concept, Your Honor, centers his health. The court's aware of some basics with his health, Your Honor, as much as we could get from the Janes. He's had ups and downs of that treatment. He's always complied with it. Bone marrow transplants, stem cell transplants. But currently, Your Honor, there's problems. There's blood being lost. They can't find out why and what's causing it. The key is, I think you've been informed, is that infection is basically a death sentence for him. And unfortunately, our jails and our prison systems, that's a much higher probability of receiving that. Next, Your Honor, with regards to bond, while out on bond, there were no issues. There was never an issue in any way, shape, or form with Adam. And there wouldn't be if you granted a bond. Your Honor, we would ask that a bond be set in this situation. The next topic, just for the record, Your Honor, I believe has been covered briefly, and that's the merger of the allied of the offenses. And for the record, I believe State versus Hubbard, Ohio 10th District 213 covers that, and we believe that these are offenses of similar import and therefore would merge in terms of the sentencing. Your Honor, then now towards the argument to set aside, and then specifically I'm going to start with the setting aside of the felony murder conviction and that charge. And there's two basic concepts, Your Honor, for that, with the felonious assault involved as well. And the first one is, Your Honor, that the process involving a police officer shooting doesn't exist. That doesn't exist at the grand jury. We don't know what the special prosecutors put forth. We don't know if they give Graham v. Connor. We don't know what's given. We don't know what's educated. And there's no parameters. We don't know if an expert testifies and gives an opinion. And if he or she does that, is it pro-prosecution or pro-defense? And so that system has to change, Your Honor. More importantly, Your Honor, directly, no officer in the state of Ohio should ever be charged with felony murder with regards to an on-duty shooting or on-duty use of force. And the reason I say that, Your Honor, is because they're acting within the scope of their duties. Now, that same concept has been addressed by the Supreme Court of Ohio. And the Supreme Court of Ohio addressed that with officers on gun specifications.
How is shooting an unarmed man within 5 seconds for no reason acting within the scope of your duties? How is that part of your duty?
And that was State v. White that the court is now very familiar with. So that case went up because the court sentenced an officer on a gun specification. So Justice O'Donnell, in writing the majority opinion of State v. White, and I quote, said, "A firearm specification is not intended to deter a peace officer from possessing a firearm because an officer is required to carry a firearm, permitted to use it when necessary in the course of carrying out the duties of law enforcement. The General Assembly did not intend the firearm specifications to apply to a police officer who fired a gun, issued to him to protect himself, fellow officers, and the public when he thought someone was about to brandish a weapon." That's a direct quote. Again, they're required to carry a weapon. They're required, Your Honor, in this situation to respond to a threat. They have to perceive it and they have to respond. They can't not do anything.
And that's crazy to hear this prosecution sitting here arguing against the same thing that the prosecution for the basketball player, I forgot their name, for the Orlando Magic, the one that was on trial today, and he's sitting there crying about the same thing. And he was yelling, well, allegedly yelling at the dude to leave and telling him to get off the property, and he felt threatened like over and over again. But Over here, they fighting for the complete opposite. It's crazy. They could do both.
That's a violation of their duty. Justice O'Connor, in another concurring opinion on that, continued to emphasize what she described as the absurdity resulting from the application of a firearm specification in a case that revolves around whether the officer made a mistake in judgment. That's exactly what we have in here, Your Honor. Mr. Coy was mistaken about whether there was a silver snub-nose revolver in Mr. Hill's hand or a set of keys. But he perceived that, and he perceived a threat. He was mistaken. Now, if you take the same logic that the Supreme Court analyzed the State v. White on gun specifications, and you apply it to felony murder, okay? So on felony murder, Your Honor, for the record, felony murder, the purpose is to deter inherently criminal behavior while committing a felony of the first or second degree. The classic example is if two people go to rob a bank. They're agreeing in criminal intent to rob a bank. The one person's the lookout, the other person goes in with a gun. The person who's lookout doesn't know he has a gun, but goes in, there's a problem with the teller, and there's a shooting. Because they formed the criminal intent for a felony of the first or second degree, and then someone died, both parties are guilty of a felony murder. It was intended to stop the use of felonies of the first degree, or to deter it. Even if a person went in without a gun and said, hey, give me all your money, and pretended to have a gun, and the teller had a heart attack, that person's guilty of felony murder because they had a prior belief, a prior intent to commit a bank robbery, and they were doing it, and then someone died during the result. So the criminal intent to commit a crime is of the first and second degree. Now, Ms. Stevens and I have spent a lot of time lately scouring the legislative notes of felony murder. And not one place in the legislative notes that our legislature puts forth do they ever talk about the concept of felony murder when they created it, when they put it into a law and into the Ohio Revised Code and jury instructions from it, did they ever mention a police shooting on it? Because it would never enter their mind, because it doesn't make logical sense. No officer says in their mind when responding or reacting to a perceived threat, I'm going to commit a felony. And because of that felony, someone dies. That doesn't happen, Your Honor. That's not the training. The absurdity of that charge being used in this situation has enabled special prosecutors and prosecutors' office across the state to weaponize laws. And when I mean weaponize laws, these are laws, felony murder, meant for violent offenders, and to use it against those now tasked with upholding the law. So they're taking a law, felony murder, that is to deter violent offenses by criminals, and they're using it against people who have to uphold the law. Just like the gun specification, the initial thing is deterrence about people using guns. If you voluntarily...
So what you saying is that the cops are above the law. People that get felony murders, it's not the same for police officers. They're above the law. You got to use a different law for them. What? How, Sway?
Use a gun, and in your criminal offense, you get an enhanced penalty. So the legislature said, hey, the punishment there should be enhanced because you're voluntarily using this gun. You made the choice to use the gun. Same way with the general deterrence of a gun specification, to deter others from doing it. That's the same concept with felony murder. Every single person in this courtroom, Your Honor, knows that Adam Coy didn't abandon and stop eating his lunch that night to go commit a felony. He announced gun to his partner. He has a gun. He made a mistake. To use felony murder on a life sentence with no chance rolled for 15 years on a mistake, on an on-duty, on a perceived threat, shows the weaponization, shows the absurdity of that charge, Your Honor. Judge, we had a conversation on the record in back. We were determining what evidence to leak, many times, sidebars in the back, outside the presence of the jury. And you were tasked that night to watch the video and see. You came back on the record and said, when you realized Adam finding out that Mr. Hill didn't have a gun, you stated he looked like an empathetic human being who just found out he made a mistake.
That's a fact. TSC, no accountability. If anybody else, like they do in these other trials, when they don't claim it, they want to give them the maximum sentence because they saying that they didn't take accountability. You're not able to admit your wrongs. You think you did right. You're supposed to get more time for that, right? They usually do. Why y'all don't?
Mistake. That's what happened here, Your Honor. Everyone knows he didn't go to Oberlin Drive with the purpose of committing a felony. And that's the issue with felony murder. That's the problem that we have when the prosecutors decide to use that. So I implore our county prosecutor, I implore the people who do these types of cases to examine that and our legislature to look at it. But you can take a stand and overturn that, Your Honor, and set it aside. Now, reckless homicide, one of the charges here, I understand the logic. I understand they're given a police officer procedures. Whether they follow them or not, an officer could be reckless in their duties. Absolutely. That's a logical conclusion and argument that jurors have to go through, and I respect that. But to then do it on felony murder, Your Honor, is just wrong. The second area that I want to talk to about the felony murder and why you should set it aside, Your Honor, is that we talked about OJI, the Ohio Jury Instructions, okay? And we don't have them, so there's no guidance, there's no tested, there's no improving, there's no not improving. So what we have, Your Honor, is it starts with the federal cases, civil, but the federal system also has a criminal charge just for these types of situations, and it's called a violation of civil rights. And that's evolved over how many years in our judicial system, in our criminal justice system. So when you have a violation of civil rights, when a law enforcement comes into contact with a civilian, there's measurements federally, and there's procedures. Now, you gave, you let the experts opine on the federal standard of within the national standards and things of that nature, and that was your choice. Other judges here in this county use the state where it's reasonable. But when you take that, Your Honor, the issue is that specifically tailored those procedures to a violation of civil rights. That's why they apply it. So you have a checklist, you have a guide, a roadmap of how to follow and whether it matches or not. So it makes logical sense, just like reckless homicide does, a violation of civil rights in federal court makes sense because it's a known thing. But when you apply those standards of whether or not they follow the national standards, policies and procedures, and you apply it to a state case, a state code, a state charge of felony murder that has never been contemplating a police shooting, that's where the jurors have trouble. No one will convince me that the grand jury in this situation understood the complexities of felony murder and how the case law and Graham v. Connor and all those go to apply to it. And that's why the system has to change. It has to be modified.
Wait a minute. Now they want to change the system? Now they want to modify the system? You hear this, Brown Sugar Babe? What is he talking about? Now they want to make changes because your officer getting locked up? Are you insane? Rock Solid TV, what's good, my ninja?
The analysis that we put the jury in was if you find that the officer didn't comply with those standards, or did, if you find that they didn't, somehow the jump goes to, therefore, he must have had the intent to do a felony. If he didn't follow those, he must have had the intent to commit a felony for felony murder. And that's just wrong. That's inconsistent with logic. It's inconsistent with the federal system. It's inconsistent. And it's our fault as a justice system because we don't have any instructions on this. We don't have OJ on it. We haven't tested it. We haven't put it through the committees. We haven't put it through the steps that happen, Your Honor. Adam Coy had no intent to commit a felony at that instant when he had to make a split decision, Your Honor, that they're trained on each and every day when they go to their job. We believe in the criminal justice system. We believe, Your Honor, at this council table behind us in the jury system. We have to, because if not, then what's the point? Everyone in this courtroom believes in that process. And we will believe in the appellate process, Your Honor. I was disappointed today, this morning, when I found out that our county prosecutor was having a press conference outside the courtroom right after this. At first, I'm like, oh, why would you politicize this? Why? I mean, and more. Again, hopefully it's going to be for good, and hopefully it's going to be improved, and hopefully it's going to be improved and say, okay, hey, this is a wrong charge for these types of cases. Our system is imperfect. There are innocent people in prison. We know that. We know that from this DNA cases in Illinois, here in Ohio. We know that. Sometimes juries get it wrong. That's why we have an appellate process, Your Honor. Adam will appeal in this stuff. I've had him sign the notice of the timing, Your Honor. I've had him going through that. We will order the transcripts, and we will continue this in a respectful way. And I appreciate your time, Your Honor, your consideration. Thank you.
Okay, thank you. On behalf of the state.
Thank you, Your Honor. Just briefly, with respect to the arguments regarding setting aside the jury's verdict, the state respectfully asks the court to overrule that request from defense. The defendant raised an affirmative defense to attempt to demonstrate that his actions were reasonable, that he was justified. He failed to make that defense. He didn't meet that burden. So the arguments about the felony murder rule and intent and not knowing what happened at the grand jury and issues with jury instructions, all of those things are things that are not for the court's consideration at this point in time. He can appeal those things, but we went through the process. We addressed all of the things that needed to be addressed. Defense was involved with the jury instructions. They've had several trials involving officer shootings. I think to argue at this point that the
I know there's a lot of Mr. Cleans in the courtroom, or am I tripping? I see 4 of them, huh? 1, 2, 3, 4. That's a lot of Mr. Cleans in there at one time now.
the instructions were unfair is just simply not true. Additionally, with respect to the issue of bond, it's the state's position that Mr. Coy is not entitled to a bond at this point in time. He has been convicted. The landscape is changed now. There are considerations that the court needs to factor into that decision. At this point, because he has been convicted, he does not have a right to a bond under 2937.722. It's the state's position bond should not be granted under Appellate Rule 8 at this point in time. Since he has been convicted, and based on the nature of the crime here, we're talking about a murder conviction, it's inappropriate to grant bond at this time. The incentive to flee at this point becomes greater because of the conviction. Mr. Coy also, because of his position in the community and access to family, friends, et cetera, likely would have the financial means that maybe the average citizen may not have in terms of being a flight risk as well. This issue can be raised with the Court of Appeals, and therefore it's the state's position that the request for bond should be overruled, as should the request to readdress felony murder rule. Thank you.
Thank you.
So that's the prosecution right there. She trying to get the judge to deny bond because they trying to get out so they can appeal the case. He want to get out already. He just getting sentenced. He ain't even sentenced yet, and he already trying to get out for bond and get appeal. But she asked for that denial though.
Any response?
No, Your Honor.
Okay. First, as to the motion to set aside the verdict, the court, I think, previously had already made a determination as a matter of law that the matter could go to the jury, that the state had presented sufficient elements of each and every element of the charge for the jury to make a determination and consideration as to all of the charges that were before them. The court still finds as a matter of law that the motion to set aside the verdict will be denied. As to the question of bond, at this time the court is not going to grant bond in this matter. The defendant has been convicted of a serious offense, and all of the reasons outlined by the state are concerns as well. Obviously, that's an issue that can be raised at the Court of Appeals, and if they decide to place on a bond, that would be their decision. Okay, I think it's already been noted on the record that each of these offenses merge for sentencing purposes, and the state has elected for the court to sentence as to count one. Therefore, the sentence of the court is the following. As to count one, there is a sentence of 15 years to life to be served at the Ohio Department of Rehabilitation and Corrections. Fine and court cost are waived. Record does reflect 274 days of jail time credit. Because of the fact that Mr. Coy will be going before the parole board after 15 years, post-release control doesn't apply, and he will go before the parole board at the appropriate time. These cases are always very difficult. Court has these types of cases in which individuals on both sides of this sit before the court. First of all, I want to echo what Mr. Collins said. I think everyone has been respectful throughout this process. Trials, by their very nature, as they always start off, are very emotional and difficult for people to have to sit through. The court absolutely understands that and gets that. And sometimes it's too difficult for people to do so. But the court, throughout this entire process, has not needed to admonish anyone about their behavior throughout the process. And so the court appreciates that as well. I think it was said by Ms. Carissa Hill, it really doesn't matter what the court ultimately does today in terms of sentencing. What we try to do is provide whatever anyone defines as justice. What the court does is not going to bring back Mr. Hill. What the court does may not bring closure to the family. What the court does may not bring healing to the family. I don't know that the court system is designed to be able to do all that. What the court has to do is take a look at the information before it and impose a sentence that the court finds is appropriate as prescribed by law. And that's what the court is doing in this case. I think it was also indicated how cases such as these impact both sides. Yes, it's something that all the families are going to have to live with. But yes, Mr. Hill, though, will not be here to have opportunities to spend time with his family. I know that the jurors took this matter very seriously in their deliberations and reached what they consider to be a fair verdict in this case. The court knows, because of the types of cases that the court deals with every day, that the jobs of law enforcement is difficult. I think everyone in the community gets that. Yes, they're difficult jobs that require split-second decisions. And what the community hopes is that we hire individuals and train individuals that when the moment comes to make those split-second decisions, that they make the right decision under the circumstances. And we know that the circumstances change and the circumstances are different. So that's why officers carry such a large amount of responsibility in making the decisions that they have to make. Now, just like the jury, I obviously had an opportunity to review the video as part of the evidence in this case. And I guess, I mean, the jurors didn't say this, but at least in my reviewing it, assuming they placed some weight on the fact that Mr. Hill did absolutely everything that you asked him to do. You asked him to come out. You asked him to come out with his hands up, and that's exactly what he did. It was not like Mr. Hill was trying to evade. It wasn't like Mr. Hill was running at you. He was doing exactly what you told him to do, which is come out of the garage with your hands up. And so I think that carried a lot of weight when we look at the responsibility that we place on law enforcement to make the very difficult and tough decisions that they have to make each and every day. And it may be troubling to the community. I can't speak for the community. But that when someone complies with everything that the officer asks them to do and still gets shot, that officer, that individual needs to be held responsible for the actions that they took. And I think that's what the jurors did in this case, and that is why the court is imposing the sentence that the court is imposing in this case. All right, Mr. Coy, Mr. Collins did provide me the certificate of defense counsel. This is essentially acknowledging that you know and understand that you do have the right to appeal this decision. And I'm assuming that you've already had discussions at this point in time about counsel. And Mr. Collins, it's my understanding the court will not need to appoint counsel, that counsel has been retained.
Counsel's already in place and will go forward, and he does not need a court-appointed appellate attorney. The only thing I know that we'll be applying for is for the indigency in terms of the transcript, Your Honor.
Okay. Okay, Mr. Collins, if you could pull up the notice.
Put your fucking hands out to the
On
side.
the screen.
Hands out to the side now. Roll to your stomach now. Yeah. Hey, don't get fucking close. I can't see his fucking hand. Get your hand up from underneath you now. We got a medic coming. Don't move, dude. Fuck. Roll over, dude.
Okay. Hold on. It should.
This is the notice that you signed.
Is it up on your screen?
It is, Your Honor. Yes.
All right. Mr. Coy, you should see on your screen, notice of duties to enroll as a violent offender. Do you see that, sir?
Yes, Your Honor.
And looking down, I see what appears to be a signature here. Is this your signature?
Yes, Your Honor.
And I'm assuming that Mr. Collins went over with you what these responsibilities will entail once you are returned to the community.
He did.
Do you have any questions about your obligations and responsibilities to enroll as?
Crazy work right there. Then, like I said, they sitting there walking past him back and forth, like the lady said, walking over him for over 5 minutes about 7 minutes, and he just laying there dying. Didn't give him no type of medical assistance, no type of treatment, no type of help until the supervisor came and like, did y'all do anything? Y'all gonna help him or what? Like, you know what I'm saying? Then they start trying to help him, but first they put him in handcuffs. While he's sitting there dying, can't breathe, you could hear him breathing. This officer over here choking in the background. Let me see, I might play a little bit. While I cue up the next one. We're going to get to the opening statements right now. Let me load that up while this is playing. And then after the thing, he walking around, they talking to him, what do you want to do? They asking him, what you want to do? Where you want to go? You want to go over here? You want to go over there? You want to get stuff out your car? You want to go get your water? You want to go grab stuff or whatever, you know, letting them dig through his car and all type of stuff. Ain't no telling if he got rid of some type of drugs he was on or pills or all types of stuff it could have been. He's supposed to be contained, right? After a shooting. They ain't supposed to just let him just roam around. Coughing and spitting everywhere. Alright, I'll mute that because we don't want to hear all that. I just wanted you to hear a little of it. But alright, let me load the next one up. Crazy business here they got going on, man. And they say we not supposed to run though, right? You not supposed to run. Don't resist. Man, but y'all got a license to kill us. Even if we not doing nothing wrong. We ain't running because there's something wrong. We running because y'all out here killing us.
Just leave the notepads in the seats, and we will collect them at the appropriate time.
So this is the opening statements. We're going to start with the prosecution. I don't know. I haven't watched this yet. I'm watching it live with y'all. I was doing some editing. I've been doing a lot of editing, a lot of recording, but man, all that stuff been building up, and you know, it's getting overlapping. So I'm gonna have to start streaming some of these live so I can edit in the background. But appreciate y'all. Hit the like, hit the subscribe, tap in, share with a friend. Let's get it.
When you go back to deliberate, okay, you will have your notepads with you. But please just remember, just because one who you see aiming or whatever the reason may be, that you think, okay, well, that's not a big deal. So on behalf of the state.
Thank you,
Your Honor, counsel, ladies and gentlemen of the jury. December 22nd, 2020 was a cold night in Columbus, Ohio. That night, Andre Hill drove to 1062 Oberlin Drive in Franklin County, Columbus, Ohio, to meet with Destiny, a woman who he knew who lived at that address at 1062 Oberlin Drive. Andre drove a silver-colored SUV to Oberlin Drive. The SUV belonged to his boss. Andre had been using the vehicle to work a job while his boss was out of town. The SUV was what many would consider to be a work truck, a work vehicle that was filled with tools and equipment. When Andre Hill arrived at Oberlin Drive, he parked the vehicle on the street near 1054 Oberlin Drive and waited for Destiny to come out to meet him. Because it was cold, Andre was periodically turning the vehicle off and on to stay warm over a period of a couple of hours while he waited. The periodic stopping and starting of the vehicle engine attracted the attention of a neighbor. It attracted the attention of the resident at 1054 Oberlin Drive. His name is Robert Ronker.
So they was there for a sound disturbance call, noise complaint for a neighbor because he kept starting and stopping his car in the cold. That's why this is why they showed up.
Ronker was disturbed by the noise, the stopping and starting of the engine. So he contacted police to report it and was advised that an officer would be out to check on the situation. Mr. Ronker made that call just before 1:30 in the morning on December 22nd, 2020. As a result of that call, Officer Adam Coy was dispatched to Oberlin Drive. Upon arrival, Officer Coy was initially investigating a vehicle that was parked in front of Mr. Ronker's residence at 1054 Oberlin Drive. However, Mr. Ronker noticed that Officer Coy was looking at the wrong vehicle. So Mr. Ronker came out, approached Officer Coy to advise him that the vehicle in question had actually moved up the street and was now parked along the side of the street at 1070 Oberlin Drive. Officer Coy then moved his cruiser closer to the location where that vehicle was parked. Andre Hill was inside that vehicle. Officer Coy had a brief conversation with Andre Hill while Andre Hill remained in the vehicle. During that conversation,
So they already had an interaction before this. You had already talked to him prior to this.
Andre Hill advised Officer Coy that he was waiting for someone, and he showed Officer Coy a text message from his phone that said, "I'll be right out," or words to that effect. Officer Coy then told Andre Hill that was fine, and he returned to his cruiser to wait for Andre Hill to leave. Around that time, a second officer, Officer Amy Detweiler, arrived on the scene. Officer Detweiler and Officer Coy had a very, very brief exchange about the situation and determined that they needed to approach Andre Hill, who had actually just entered the garage of the residence at 1062 Oberlin Drive, the residence where he was waiting on that person to come out. Now, here we have a photograph of that garage. At this point, Officer Coy and Officer Detweiler made their way up the driveway of 1062 Oberlin Drive towards the garage where Andre Hill was inside the garage. Officer Coy ordered Andre Hill to come out of the garage. Andre Hill began to comply with Officer Coy's orders and began to move towards the open garage door. He moved alongside a white car that was parked in that garage. Andre Hill had a cell phone in his left hand, which he had raised up towards the officers as if to show them something on the phone. His right hand was not visible. After Andre Hill rounded the rear bumper of the white car, Officer Coy yelled "gun" and shot Andre Hill 4 times, killing him. The evidence will show that Andre Hill was not armed. He did not have a firearm. When the crime scene was processed, BCI agent Asia Chung recovered items at the scene, including a cell phone, including keys in the area where Andre Hill was shot, but there was no firearm. You will hear from a number of witnesses in this case, among them Officer Detweiler, the second officer who was there. You'll have the opportunity to view body-worn camera of Officer Detweiler, as well as body-worn camera of Officer Coy. Keep in mind, as you're viewing this, that the officer's body-worn camera was not on during their initial approach. So there are some portions of the events that were either not captured on video or that were captured without sound due to a feature on the body-worn camera that records the 60 seconds of video prior to the body cam being turned on, but records it without sound. In addition to viewing the body-worn camera, you'll also hear from Robert Ronker, the 911 caller, as well as other witnesses. Adam Coy has been indicted for 3 crimes. Those crimes include the crime for killing Andre Hill, a crime for felonious assault, and crime for reckless homicide. Let's run through what each of those entail. The first one, causing the death of Andre Hill. The state of Ohio has to prove beyond a reasonable doubt all the elements of these 3 offenses. What does the state of Ohio expect to prove? That the defendant, Adam Coy, caused the death of Andre Hill as a proximate result
This is something that don't happen often, though.
of committing or attempting to commit felonious assault, which is an offense of violence of the first or second degree. That's the first offense. Now, as part of that, the state has to prove that the defendant, Adam Coy, acted knowingly in causing the death of Andre Hill. What is knowingly? A person acts knowingly, regardless of purpose, when the person is aware that his conduct will probably be of a certain nature or a certain result. A person has knowledge of circumstances when he is aware such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances in evidence. This is that mental element that the state will have to prove. The second crime, which the state has to prove beyond a reasonable doubt was committed by Adam Coy, is felonious assault. What's felonious assault? What does the state have to prove? The state expects to prove that the defendant, Adam Coy, knowingly caused serious physical harm to Andre Hill, or alternatively, that Adam Coy caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. That's the second offense. The third offense is reckless homicide. The state has to prove beyond a reasonable doubt that the defendant, Adam Coy, recklessly caused the death of Andre Hill. And here we have a definition of recklessly, that mental element that we've been talking about. In order to prove recklessly, the state has to show a person acts recklessly when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk, that that person's conduct is likely to cause a certain result or be of a certain nature. A person is reckless when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk that such circumstances are likely to exist.
So these are the burdens they gotta prove when trying to convict the cop of being guilty, but they don't show all this when it's a regular person.
The state of Ohio expects that at the end of this case, it will have proven to you beyond a reasonable doubt that the defendant, Adam Coy, is guilty of all three of those crimes. Now, the state also expects that the defense will assert that Adam Coy's use of deadly force against Andre Hill was reasonable and lawful in his official capacity as a police officer, and thus the state expects he will submit that he was justified in his actions. The defense will have an opportunity to present evidence to establish that defense called justification. In order to establish justification, the defendant, Adam Coy, has to prove that he was justified in using deadly force by a preponderance of the evidence. The state then has an opportunity to refute Officer Coy's use of deadly force was reasonable or justified. In order to do that, the state expects to call an expert witness, Seth Stoughton, to testify regarding national police practices, and the state expects that that expert will opine that Adam Coy did not act within those practices. Let's run through the justification, defense, and reasonableness. The standard for determining whether or not the use of deadly force by a police officer is justified is a reasonableness standard. If the officer reasonably believes deadly force is necessary to defend himself from the actual use of force or from the imminent use of physical force by a suspect that poses a threat of death or serious physical harm to the officer or others, then the officer's use of deadly force is not unreasonable. Keep in mind, reasonableness requires careful attention to the facts and circumstances. The reasonableness standard of a particular use of force must be judged by the perspective of a reasonable officer on the scene, not with the 20/20 vision of hindsight.
So what is this reasonable officer? What do we consider a reasonable officer? Because that's one thing they always getting away with, like, you know, saying that it was a reasonable officer, it was justified. Like, where is the standard for that? Do they have a level, like, where we can gauge if this officer was reasonable or not? Like, are we able to look into their mental history or into their past history? Is that part of it? Or do they just get to keep all that to themselves? Just a question.
The standard of proof for proving that justification defense is a preponderance of the evidence. That's the slightly more than 50% standard that you've heard about in voir dire. So in order to prove that he was justified in using deadly force, the defendant, Adam Coy, must prove that he was justified by a preponderance of the evidence. The preponderance of the evidence is the greater weight of evidence. It is evidence that you, as jurors, believe because it outweighs the evidence that is opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. If the weight of the evidence is equally balanced, or if you as jurors are unable to determine which side of the issue has proven the preponderance, then the defendant, Adam Coy, has not established the defense of justification. The defendant, Adam Coy, may call his own expert witness to give an opinion about the events that occurred that night on December 22nd, 2020. And that expert may give an opinion as to whether or not Officer Coy's actions were justified. In addition to the opinions of any defense experts, you may also hear evidence related to Adam Coy's version of events that took place that night. The state of Ohio asks you to listen carefully to that information, to critically examine and analyze all of that information. This is something that you'll likely circle back to at a later point. Ultimately, ladies and gentlemen, the determination as to what happened that night and whether Officer Adam Coy's actions were reasonable or justified will be up to you. At the end of this case, the state of Ohio will ask you to find that Officer Coy's use of force was not reasonable, that Andre Hill followed the commands of Officer Coy, that Andre Hill was not a threat to Officer Coy or Officer Detweiler, that Andre Hill did not have a weapon, that Officer Coy's actions were not reasonable under the circumstances, and that Officer Coy was not justified in shooting and killing Andre Hill. At the end of this case, the state of Ohio will ask you to find Officer Adam Coy guilty of all three of the offenses with which he has been charged. Thank you.
Guilty. Guilty. That nigga
Thank you,
guilty.
Sam.
Ain't that nigga now? I got the rope right here. I need to go grab a Uncle Rook, because I can't believe I
behalf of
still
the
ain't
defendant?
got that yet.
Thank you, Your Honor.
I should have been grabbed that clip. I mean, I got it, but I'm surprised I ain't put it on here. So I guess this is the, yeah, that's her. This is the defense
May I proceed?
You may.
with
May it
her
please the
opening
court?
statement.
Mr. Collins, Mr. Coy, Mr. Pearson, and Miss Amlin. Good morning, ladies and gentlemen. The state of Ohio just told you that Adam Coy did not perceive a threat on December 22nd, 2020. The state's own witnesses will tell you that the fact that there was no weapon found on the scene does not matter, contradicting the state's theory. You are going to hear that officers do not have to wait until they see the glint of steel. That what matters is how the hand was being presented, because an action is faster than a reaction. The state's own witnesses are going to tell you that. You are going to hear that that is how officers are trained. You are going to hear from the state's own witnesses that actual possession of a weapon is irrelevant. That police officers are allowed to be mistaken. Whether you agree with that or disagree with that, that is what their training says. You are going to hear from the state's own witnesses that Adam Coy does not have to await the glint of steel in order to use deadly force. Now, you will hear that Adam Coy saw that glint of steel, make no mistake. He saw a glint of steel. He saw metal come up in a hand. Bruh. And the state's own witnesses will tell you that police officers do not have to wait. They don't have to be 100% certain that that glint of steel that's coming at them is in fact a firearm. So we ask that you keep that in mind as you hold the state of Ohio to their burden and examine the credibility of the state of Ohio's case. You are going to hear that on December 22nd, 2020, my client believed he was going to get shot. He yells, "Gun, gun," steps off the line, draws his weapon, and fires at what he honestly believed was a revolver being leveled at his direction. You are going to hear that he was mistaken, that it was not a revolver, but instead, that glint of steel turned out to be a metal mass of keys. You are going to hear that police officers are allowed to be mistaken, and you are going to hear, ladies and gentlemen, that even though there was no weapon found, though allowed to be mistaken, you are going to hear that police officers are allowed to be mistaken, and you are going to hear, ladies and gentlemen, that even though there was no weapon found, his action to respond with deadly force was consistent with national police procedures. And that is what the evidence will show. Now, opening statements. Just as the judge indicated, they're an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or is, as the case here, it's an opportunity for me to lead you down a path of what we believe the evidence will not show. For instance, the state of Ohio just tried to tell you that our client was reckless when he made the split-second decision to use deadly force. However, ladies and gentlemen, the evidence will show that our client was not reckless. He did what he was trained to do. And what he was trained to do.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
Trained to do. And what he was trained to do was shoot to stop the threat. The evidence will show he didn't act with heedless indifference. He didn't empty his clip. He was a trained officer doing what he was trained to do, to stop the hand with what he believed was a revolver being leveled at his direction. Now, every time Mr. Collins and I prepare for a case, we like to look for what we call a theme. And what I mean by theme, ladies and gentlemen, is when you have a case and examine a case, you have witnesses, some civilian, some professional. You've got some evidence, some physical, some circumstantial, and those all sit on the periphery of a case. But the theme, ladies and gentlemen, is what's at the core fundamental concept of a case. And so the theme of this case, the core fundamental concept, is one of justification. And that was because the mistake that Adam Coy made on December 22nd, 2020 was reasonable because he was acting in accordance with his training. Now that is because the evidence will show that on December 22nd, 2020, Adam Coy was justified when he made the decision to use deadly force.
So they saying right there that they train him to do that. They train him to act like he do, to respond quick and shoot quick and don't waste no time. Just shoot him.
Because number one, he had a subjective belief that he was in immediate fear of great bodily harm or death. And number two, that belief was objectively reasonable based on the totality of the circumstances when viewed through the eyes of a reasonable police officer on the scene, without the benefit of 20/20 hindsight. And that's because, ladies and gentlemen, the evidence will show that Adam Coy saw the glint of steel being leveled at his direction, believed it to be a gun. He was mistaken, and the evidence will show that mistake was reasonable. And we will prove that, ladies and gentlemen, by a preponderance of the evidence, or more likely than not. And as the judge will tell you, if you find that...
What up, Cha Diggy? Y'all show Cha Diggy some love. Drop her some blue hearts in the chat or the Cha Diggy emoji.
We have met our burden of proof of more likely than not. If we have proven justification to you, more likely than not, then that serves as a complete defense to all three charges. Now, with the benefit of hindsight, nobody in this courtroom disputes that December 22nd, 2020, the events that occurred were tragic. And it's not lost on us that someone lost a life, someone lost a father and a friend. However, as the judge told you and will continue to remind you, that when you examine a case, when you analyze and when you decide a case, you must not consider sympathy or empathy. And it is a tough task, ladies and gentlemen, because undoubtedly the state of Ohio is going to try to use that we are all humans in this courtroom. I am warning you now that it's not easy. And it doesn't get any easier the more times you see a body-worn camera or the more times you see a gruesome photo. I am sure they will play the body-worn camera over and over and over again. They will slow it down for you, go frame by frame for you. They're going to show you graphic photos. They're hard to see. It's hard to hear. And it's hard because we ask you to be almost clinical in your analysis. But that's what the law requires. Again, whether you agree with it or disagree with it, that is what the judge has already told you, and I promise you he will tell you again. And so every time the state plays that video, or you see that picture, you see that body-worn camera go frame by frame, Mr. Collins and I would ask that you keep in mind that admonition that the judge gave you, that as you took an oath as a juror, you are not to consider sympathy or empathy when deciding this case.
The complete opposite of what y'all do when we convicting some of these young black men on the streets, like the other officer out there in what was that, Jacksonville, Florida? The one that's going through it right now just released more body cam. I got some recordings of that I'm going to release too. I'm working on the video for that, but it's coming out soon. Crazy. It's complete opposite. They fighting for the complete opposite.
Now, unlike the majority of the cases that we try in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting its burden. It is they that must prove to you, beyond a reasonable doubt, each and every element of all three crimes charged. Beyond a reasonable doubt is our highest legal burden in our system. As the judge will tell you, It's proof of such nature you would rely upon it in your most important of your own affairs. Care for an elderly parent, surgery for a child. And if they fail to prove all of those elements to you beyond a reasonable doubt, the judge will tell you your analysis stops there. Now, you're going to hear two competing theories that the state is pursuing against our client. One is saying that he shot to injure Mr. Hill, that he knowingly committed a felonious assault, which proximately resulted in the death. The evidence will show that he's not trained to shoot to injure. He's not trained to shoot to kill, but rather the evidence will show that he is trained to stop the threat of what he believed to be a revolver. The second theory.
So was he not trained to try to save the guy after he shot him? Was he trained to just walk around him coughing and spitting up all over the ground instead of trying to help the guy that he just shot? Ain't that supposed to be part of their training, to make sure that the person they shot survived?
Is that he did not act knowingly, but rather he acted recklessly, with heedless indifference concerning the consequences of his actions. Again, ladies and gentlemen, the evidence will show that Adam Coy did what he was trained to do on December 22nd, 2020. Not shoot with heedless indifference, but trained to shoot to stop the threat. The evidence will show they are not going to meet their burden of proof. Because the evidence will show, ladies and gentlemen, that the state started from a premise and worked backwards. The state will not be able to prove any of the mental elements beyond a reasonable doubt because of those conflicting theories. The state's own witnesses will support the defense of justification. And the expert that the state is going to call, a man by the name of Seth Stoughton, he comes to multiple conclusions. Listen to those conclusions, ladies and gentlemen. One is contradictory to what the judge is going to tell you. And a separate conclusion is the same exact conclusion that the defense experts come to. And that is that he will tell you, if an officer believes a gun to be pointed at him, then that officer is just...
Even the Queso trial, they got no video of Queso being there. Most of the evidence say Queso not there. They don't have the murder weapon. They don't have no video of it, but they sitting here trying to lock him up and trying to do everything they can to make sure they lock him up. But here, this dude is on body cam, wrongfully killing somebody, and they got the gun and all that stuff, but they fighting for the complete opposite. It's crazy.
Justified in shooting. So that is why the state of Ohio will not be able to meet its burden. And again, if that is the case, the judge will tell you your analysis stops. But even if you find that somehow, despite what I've just told you, that the state of Ohio does in fact meet its burden, then and only then do you analyze the defense of justification. May I have the Elmo, Judge?
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
I don't know what I said, but I was high every day for a whole year, and I was at anything. I was at done anything to get out of here. I was at done anything.
And so this is the flow chart of how your analysis will go. First, you will analyze, did the state meet its burden of proof beyond a reasonable doubt? If no, your analysis stops there, and your verdict is not guilty. If yes, then you must analyze the defense of justification. You must ask yourselves, did the defense prove justification by a preponderance of the evidence, or more likely than not? If yes, then your verdict will be not guilty, and if no, then your verdict will be guilty. Thank you, Your Honor. And so I want to talk about our burden, ladies and gentlemen. It's different than the state of Ohio's. Certainly not as high as the state of Ohio's. But we welcome that burden, ladies and gentlemen. We have to prove to you that our client was justified by a preponderance of the evidence. As the judge will tell you, a smidge over 50%, or more likely than not. So as you listen to the testimony and the defense that we put on, remember, we have to prove 2 prongs to you by preponderance of the evidence. Number 1, the subjective component, that it is more likely than not that Adam Coy had a belief that he was in imminent fear of great bodily harm or death. And number 2, the objective component, that it is more likely than not that his decision to use deadly force was reasonable, given the totality of the circumstances in the eyes of a reasonable police officer on the scene, going through everything my client did on December 22nd, 2020. Now, this is where the mistake comes into play, ladies and gentlemen. In that calculus of reasonable, we have to prove that the mistake Adam made was more likely than not reasonable, given the totality of the circumstances. Again, we have to prove that by a preponderance. So I'm asking that you keep those 2 components of justification in the back of your mind as you are listening to the testimony here. Is it more likely than not than when Adam saw what he believed to be a gun? Is it more likely than not that he was in fear for his life? And number 2, is it more likely than not reasonable that he made a mistake when he saw the steel, the metal that resembled a gun in both size and color? Now, your task is not an easy one, and the judge is going to instruct you that you must analyze that second component from the eyes of a reasonable police officer on the scene. You must examine the totality of the circumstances, and the judge will tell you, can't use hindsight in your analysis. The judge will tell you, you must account for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving about the amount of force necessary in a particular situation. And there's a reason why the law of justification, ladies and gentlemen, is written in this fashion. And that's because unlike judges, unlike juries, unlike me, officers on the beat are not afforded the luxury of armchair reflection. Every single day, our men and our women on our police force put on their uniform, not knowing if they're going to return to their home or their armchairs for doing their job. And the court will tell you that you have to take that into account, that they're required to do their job. Now, let me tell you a little bit about Adam Coy. 2 days after high school graduation, he joined the Army, was honorably discharged for fighting our country and earned a rank of Sergeant E5. He returned from the Army and immediately began his career in law enforcement. He's got 3 kids and a wife, and on December 22nd, 2020, he faced every law enforcement officer's nightmare. You are going to hear that on December 22nd, 2020, a little after 1:30 a.m., Adam was in the area of Ackerman and Olentangy when he was dispatched on a call for service to Oberlin Drive, 1054 Oberlin Drive. That was the first house that you guys went to on your jury view. He was dispatched on a 4848A, suspicious car, suspicious person report, because there was an SUV that had been turning off and on for some time. Adam arrived to 1054 Oberlin and approached that SUV that was in front of that address. The caller met Adam outside and told him, hold on, that's the wrong SUV. The SUV that was in front of my house had since moved, not to 1062, but to the third house that you guys went to, past 1062, down to 1070 Oberlin Drive. That SUV was in fact in front of 1054, but that suspicious vehicle had moved to 1070. So Adam pulls his cruiser behind the SUV and exited the cruiser, as he was trained to do. He pulls offset, meaning he pulls up behind the car, but not directly behind, a little bit offset, as he was trained to do. As he approaches the driver's side of the SUV, the driver rolls down his window, makes an X with his arms, with a cell phone in his right hand. He leans over as if he was hiding something. Before Adam can get a word out, he was shown this phone. And based on those actions, it was Adam's understanding that somebody was going to come outside, that he was waiting for someone. So based on these actions, the call, the fact that a suspicious person was sitting in a...
Officers left him lying there without giving any first aid. Mr. Hill was wearing a Black Lives Matter t-shirt under his sweater, calling for justice for George Floyd.
Let's cuff him up.
Copy. It then took between 5 and 13 minutes before anyone attempted to save Andre Hill's life, according to his family's lawyer.
Everybody turn your cameras on. Cameras on. Anybody doing anything for him?
Negative, sir. We contact medics.
I copy.
Get some gloves. You got gloves on?
Yes, sir.
Start pumping his...
Want to speak to Adam Coy, that he appeared wide-eyed and jittery. Adam decided to watch, to make sure that what his understanding was, that this person was waiting for somebody, that was in fact the case. So he returns to his cruiser and he waits until in the area. He wants to see, is a person gonna come out to the car, or is this person just going to leave? He's waiting for that. Now, what Miss Amlin didn't tell you, ladies and gentlemen, is that Adam gets back to his Columbus police cruiser. He opens the door. He sits in the cruiser.
She really fighting for this. That's wild. What up, Joni Ford? I see you. Appreciate you joining.
With the door open, as he was trained to do. And after about 1 minute, the person in the vehicle opens the door of the SUV. He exits the SUV. As this is happening, Adam gets out of the driver's seat of his cruiser, stood next to his cruiser to observe what was going on. The person walks behind the SUV directly in front of Adam's cruiser, and he didn't go to the house that he was parked in front of. He didn't go up to 1070 Oberlin Drive. Instead, he went up to 1062 Oberlin Drive, and he pounded on the door. Nobody comes downstairs. Nobody turns on any lights. He waits and waits, just less than a minute, and then proceeds to pound hard on the front door again. Again, all while Adam is observing. There's still no movement in the house, and it has remained dark. The person who is pounding on the door walks back to his SUV, opens the driver's side door, leans in and is rummaging through some things as if he were looking for something. He then walks back toward 1062 again. And Adam asks, hey, what's going on? And the person ignores him. Adam watches the person continue to ignore him, and as he's doing so, he keeps looking back to see what Adam is doing, seeing what Adam's response was.
But where is the crime, though? Like, she talking about all this stuff he doing. Where is the crime? Like, what are you talking about? Ain't none of that illegal that you mentioning. Why are you even talking about all this stuff? What does that even matter? Why did he shoot the man? Why you not talk about that?
In the meantime, that is when Amy Detweiler pulls up. The state didn't want you to hear all of that in between, though. That is when Amy Detweiler pulls up, because she was dispatched too on the original suspicious person or suspicious call. The caller at 1054 comes back outside, and Adam yells at him to go back inside for his own safety. Officer Detweiler exits her cruiser, and she and Officer Coy briefly communicate about something not being right, not knowing what is going on with the person they were sent to investigate. In the meantime, Adam and Amy lose track of where the person went. He disappeared. It is pitch black, ladies and gentlemen, at 1 a.m. You had the benefit of going to the scene in the daylight. However, in the eyes of Adam Coy and Officer Amy Detweiler, it was pitch black that night. So, Officer Detweiler and Officer Coy do what they're trained to do. They begin to look for the person to investigate what is going on. It was pitch black in the dead cold of winter, and at this point, nothing is adding up to Adam, and he lost sight of him. At this point, he has a duty to go forward at this point. And he will tell you, I didn't know what was going on. I thought maybe it could have been a burglary or something to that effect. But at this point, I had to go investigate because I had what's called reasonable articulable suspicion to potentially believe a crime was being committed or was about to be committed. Adam Coy approaches the pine tree that you saw located between 1062 and 1070 Oberlin. The garage door was open. Something again that is not normal at 1:30 or 2 o'clock in the morning in the middle of the winter during the holiday season. There's no light in the garage. Adam sees a white car parked. He has his flashlight and he's scanning the area around the house. Initially, he doesn't see anybody in the garage. Then he sees a glow from a cell phone. He flashes his flashlight in that direction and sees the same suspicious individual that was in the car that ignored his commands huddled in the garage. Amy Detweiler has a different view. She pursues up the driveway and is to the right of Adam. As Adam is walking up the drive, he says, "Show yourself, come out here, something's not adding up."
They wasn't even there for a crime.
The
They was
person
there
turns
for a
his body
noise disturbance.
with his shoulder partially.
Oh, my bad, I stopped the wrong one. They wasn't even there for no crime response. They was there for a noise disturbance, for him starting and stopping his car, and the neighbor got mad because the sound of his car starting up was irritating him or something.
Bladed.
Crazy.
And begins walking toward Adam and Amy with his eyes fixed on Adam. The person has a cell phone in his left hand, raising about shoulder level. Adam will tell you that training dictates that he perceived that to mean he was being distracted, that was to serve as a distraction, because neither Adam nor Officer Detweiler could see the right hand. As he's approaching and as he clears the bumper of his vehicle, you will hear that Adam Coy believed a hand to be raising up, sees the metal glint of steel, yells, "Gun, gun," steps offline, and fires 4 times until he sees that threat stop and he sees that threat drop. He immediately hits his body-worn camera. Columbus Police body-worn cameras at the time only had a 60-second look-back period. So you're going to see that body-worn camera did, in fact, capture the shooting. The video does not have audio at the time of the shooting, but you are going to see how quickly this all happened, how quick Adam was forced to make that split-second decision. Now, he doesn't let Officer Detweiler go right up to the person because he believes that person still had a gun. Once safe to approach, Adam does so, and he doesn't see a gun. But instead, he sees a mass of silver keys on a key with a key fob.
Look at him. Look, able to dig all in his car. When has somebody killed somebody, then you surrounded by police, but you able to go and grab stuff? What was that package he just grabbed? Look. What was that? Hold on. What is that? Hold on. Let me pause it and blow it up. Hold on. Matter of fact, I'm going to play it in slow motion. Let me blow this up. What did he just grab? Speaking of, let me see. He getting rid of over here dumping drugs and stuff. Hell no. Watch this. Let me slow it down. Slow motion. Watch this. Watch this. What are you grabbing? What was that?
You will see this metal mass of keys, ladies and gentlemen. He realized he was mistaken about the massive keys being a revolver. He was in total shock and he became physically ill. The evidence will show, ladies and gentlemen, that based on that account of events that I just told you, that we will have met our burden. Number one, that Adam had a subjective belief, that it was more likely than not that when Adam believed he saw a firearm in that hand, that he was more likely than not afraid for his life. And number two, that he was objectively reasonable, that his action to use deadly force was objectively reasonable based on the totality of the circumstances. His actions were reasonable because he acted in accordance with his training when viewed from the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And even though that he was mistaken, the evidence will show that that mistake was reasonable because the keys were both similar in size and color to that of a revolver. Now, Amy Detweiler, the state's own witness, is going to provide you corroboration of the defense of justification. She's going to provide you corroboration that Adam yelled, "Gun, gun," before firing. She's going to provide you corroboration that he does not let her approach immediately after because he still believed that a weapon was within reach. Now, the second prong of justification I want to focus on for a moment. How are you going to know what a reasonable police officer, how that person would have acted? How are you going to know about these national police standards that the state and I keep talking about? You're going to hear from two defense experts, decorated law enforcement officers with more years of law enforcement experience than I have on this earth.
What's in his hand right here? What did he just grab out the seat that he over here tucking?
Between the two of them, they have trained thousands of law enforcement officers all over the world on deadly force. Particularly, they've trained officers in this city and in this state. Their names are Kevin Davis and Jim Scanlon, both certified trained police officers here in the state of Ohio and now retired. Kevin Davis has been in law enforcement for almost 40 years, and he's a certified force analyst. Jim Scanlon was a law enforcement officer for 33 years, 19 of which he served on SWAT. He started his own company in 1999, where he consults and trains officers with officers involved in shootings, firearms, hostage barricade situations, and critical incident training. Listen to the two defense experts and compare them to the state of Ohio's expert. The evidence will show that the state's...
All right, hold on. So real quick, we're going to go ahead and play some of this audio from that portion right there because I want to hear what they were saying right here before he grabbed that stuff out the seat. Did he talk to a cop? Because I know a cop was following him. Let's see. Oh, let me take the sound on.
That's doing me around. Come on. Let's get out of here. Come on. Come on. That's doing me around. I'm gonna throw the bag in the back. We'll just go down the road, okay? You can talk to whoever you want to talk to down there, right? You got your phone with you?
Yeah. I gotta figure out when I miss.
Huh? We'll take care of that, I promise you. We're gonna say anything about that right in a second.
Gotta figure out when I miss.
Ooh, he grabbed the stuff out the car. Then he's talking about trying to figure out what I missed. Then the cop tell him, "We'll take care of that. Don't worry about it. I promise you." What is they talking about? Are they covering something up?
Huh? We'll take care of that, I promise you. We're gonna say anything about that right in a second. I'm gonna go throw my stuff in the back, okay?
Okay.
I'm gonna go throw my stuff in the back, okay?
Okay.
So now the cop told him, I'm gonna go put my stuff in the back. Where did he leave? What did he go put in the back? What is he going to put up? The cop that's supposed to be watching him, right? What? Oh, this is where he grabbed it right here. After the cop left. Okay. He's grabbing some stuff. After the cop said, I'm gonna go put my stuff up or whatever. Now he's grabbing stuff out of the car, out the seat. A little plastic bag of brown something, and then the other thing, the second hand, his hand was covered, so I couldn't see what it was. But I did see a little brown bag in the...
We'll come back on this. We're just gonna head down,
Wait, what did he say?
head down the road. We'll come back on this. We're just gonna head down the road. Let's get you out of here for a second.
We got any bosses here?
No, Sarge's on his way. Yeah, we'll air it and he'll come down there and talk to you.
Now he's back, look. What is he doing over here?
I'll call Sergeant.
Look, you got the gloves on.
You can shut off right now.
Yeah, that'd be nice.
Now you're taking the gloves off. What did he just take over there with the gloves on?
415 and 15 secure from that incident.
Some pills, gotta be some pills. I was thinking the same thing. Hey, Miss D, Miss DB, say I fell asleep. We just doing the opening statements right now. We showed him get sentenced. The officer who shot the guy, we showed him get sentenced already. He got 15 to life. But this is the footage of the incident, which is crazy. And right now she doing her closing statements, but I just wanted to see that because I seen him grab something out the seat. I was like, wait a minute, why is they letting him just roam around picking up stuff?
Okay, if that's what you want to do, man, I'm just here. Lay the road if you want, man. I know you're kind of... What do you want? Hey, listen, what do you want?
Let's just walk over there.
Okay, if that's what you want to do, man, I'm just here.
Crazy business. But yeah, we're gonna let it wrap up. Now we on the opening statements. We just did the prosecution opening, and now this is the defense opening. Did he forget about the cows? He must have, huh?
This expert does not hold a candle to the defense experts when it comes to qualifications. Now, Jim Scanlon and Kevin Davis use different methodologies in analyzing this use of force, but they are going to come to the same conclusion. They are going to tell you why and how Adam acted accordance with national training and police procedures. They're going to help you analyze what a reasonable police officer would do. Listen, as one of our experts will tell you, why Hill's actions dictated what Adam did next. Then, after standing in Adam Coy's shoes, experience what he experienced, as our expert will tell you, listen, as they will tell you, it required immediate action on behalf of my client. One of our experts are going to walk you through some factors. These factors will be mentioned in the jury instructions that the judge will give you. Keep these factors in the back of your mind as our expert talks to you about them. Number one, the severity of the crime at issue. Listen, as our expert will tell you, that Adam Coy had a lawful objective for taking action. He had a duty to go forward. He will tell you that there is no more severe there is no more severe threat than thinking that a gun is being pointed at you as a police officer. The second factor, whether the person posed an immediate threat. Listen, as our expert will tell you, that officers are trained that the actual possession of a gun is irrelevant, that what matters is the perceived threat based on how the object in the hand was presented. There is no question, as the evidence will show, that based on training, when a perceived threat is a person with a gun, that they are an immediate threat. Evidence will show that Coy's decision to use deadly force when examining this factor is more likely than not reasonable. And the third factor that you will hear these experts discuss is whether the suspect was actively resisting or attempting to evade arrest. You're going to hear that the person was non-responsive, that he disappeared, that he ignored Coy. And so evidence will show that when you analyze this factor, it is more likely than not reasonable with his use of deadly force. You are going to hear, ladies and gentlemen, how officers are trained, what they are trained to believe as if it is second nature. You're going to hear about threat patterns.
That's part of their nature too. It's just if you want to shoot somebody, just yell gun, gun first, and usually we get away with it. It don't matter if he got a gun or not, or we could just plant one later. But just yell gun and then shoot so we can know you about to shoot.
That officers have to train to indicate, recognize, process, and respond to these threat patterns. You're going to hear that they are trained to know that an action is always faster than a reaction. You are going to hear from experienced, trained law enforcement officers that when a hand comes up, an officer does not need to be sure that there is a firearm in that hand before responding with deadly force. You are going to hear that Adam Coy waited until he saw that glint of steel come up in his hand. You are going to hear from experienced, trained law enforcement officers that an officer is allowed to be mistaken. And you are going to hear from experienced, trained law enforcement officers that a perceived threat is enough. You are going to hear and you are going to see why that mistake is more likely than not reasonable. In the dark, based on the totality of the circumstances. You're going to hear about the limitations of seeing in the dark. You're going to hear about the limitations of what the body-worn camera captures. You're going to hear time and time again that the camera does not capture everything that our eyes do. And you're going to hear and see everything that that camera captured versus what Adam Coy perceived on that night. Now, the state's expert, Seth Stoughton, I think he was a police officer for maybe 4 years and 7 months. He's got no experience here as a law enforcement officer in the state of Ohio, and certainly not in the area where the shooting took place. But even he, a much less experienced officer, will tell you that if an officer believes a gun is being leveled at him or her, they are allowed to shoot. Even he will tell you that you need not wait the glint of steel. Even he will tell you an action is faster than a reaction. And even he will tell you officers are allowed to make mistakes. In recap, ladies and gentlemen, the state of Ohio has the burden of proof here. They have to prove to you each and every element beyond a reasonable doubt. If they do that, only then do you get to our defense of justification. Our defense of justification is more likely than not. And as the evidence will show, at the end of the trial, the evidence will show that it is more likely than not that Adam Coy believed he was about to be shot because he believed that that person had a firearm in his hand. And the evidence will show that based on the totality of the circumstances, in the eyes of a reasonable police officer on the scene, experiencing what Adam Coy experienced on that day without the benefit of 20/20 hindsight, the evidence will show, ladies and gentlemen, that that decision to use deadly force was more likely than not reasonable because he acted in accordance with his training, as he was trained to do. As such, at the end of trial, my partner, Mr. Collins, will come before you and ask that you find Adam Coy not guilty of all 3 charges. And that's because he was justified when he took those actions on December 22nd, 2020. I thank you for your time.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
So that was that for that. I'm gonna play the rest. That was just the opening statements. I'll probably do the rest of that tomorrow, or I don't know, sometime soon. But before we get to that, I just gotta play this dude's testimony from today. What's his name? Lawrence Doherty, the dude that shot the Orlando Magic basketball player, and I just want to play this because then I want to see the prosecution and how opposite they talking about the same thing. But it's not that long, so we just gonna get into it before we wrap it up for tonight. My bad. But appreciate y'all being here. What up, Late Night Bacon with Mookie? What it do? I see you. Appreciate you joining, family. Let's get into it.
Rence, last name Doherty.
Spell the first name and the last name.
Lawrence, Lawrence, last name Doherty, Dority.
Mr. Thompson, you may inquire.
Mr. Doherty, how old are you?
I am 32.
You have any children?
Yes, I have 3.
What are their ages?
13, 8, and 2.
What do you do for a living?
I'm a
Bob is 2000.
Well, isn't this a nice surprise?
You actually live in this situation. You recall what happened on May 9th, 2022?
Yes, I do.
Did you explain to the court and the jury what happened?
Well, around 1:30 in the morning, me, my son, and my dad went to my house. My father was taking me and my son home. And as we arrive, I see the car parked at the corner of my home, and I automatically assumed it was Tara. So I thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. And so I walk over there to greet her, to say, hey, why are you parked here? And Mr. Payne gets out of the car. And when he gets out of the car, he's looking down at me. He has his hand in his waistband, and I can see like something silver sticking out on the side of his hip with his hand on it. And I asked him, what are you doing here? And he said, I'm not playing with you, I'll smoke you. I said, what? I threw my hands in the air. And
The absence of evidence is not the evidence of absence.
What?
Now, ain't that with the same thing she was just talking about, that silver poking out? Yo, y'all showed Joni Forrest some love. Appreciate you, family, dropping the gifted membership. Appreciate the support. Y'all show her some love in the chat. Drop some the blue jay emojis. That's for Joni. And drop some coins. Appreciate the support. But yeah, you see how opposite it is already. Because that's the same thing that they said regarding the other cop was the silver. But let's get back into it. Appreciate y'all, family. Show her some love.
I started freaking out. My dad rolls down the window and asked me, is everything okay? And I told him, I don't know. So I go inside of my home. I retrieve my firearm so I could safely get my son in the house. And so as I return back outside, I see Mr. Payne has moved his car up even more, and he's gotten out of his car again. And so I'm standing in my driveway and I'm asking him, why are you here? What are you doing here? Why are you here? Can you please leave? Can you please leave? And he's just staring at me.
Okay. How tall are you, Mr. Doherty?
5'8".
How much do you weigh?
145 pounds.
Did you have a relationship with Mr. Payne? Had he ever been to your home before? Did you invite him? I need you to make an audible.
No, sir.
Did you have a relationship with him at all?
No, sir.
Did you invite him to your home? I'm sorry?
No, sir.
out of all the years that you knew Miss Tara Walker, had you ever actually met Mr. Payne?
Like twice.
Was there any situation where you guys had a issue?
No. I just seen him one time. He showed up to my girlfriend's mother's Thanksgiving or something like that. He showed up unannounced. And I don't even recall the other time.
So getting back to May 9, 2022, when you came, why did you go back in the house? Why did you go in the house?
Because I thought I was gonna die.
Why'd you feel that way, though?
He's outside my house. He's telling me he's gonna smoke me. I have my son outside. I have my father outside. He's there by himself. Nobody. I didn't.
He said he's gonna smoke him. That's crazy. But I mean, it's self-defense though, right?
How many shots did you fire? A moment.
Just trying to go home.
Mr. Doherty, when you speak into the microphone, let's just slow down a little bit. Let's try to. Take your time and make sure you speak into the microphone, okay?
What was the question?
At some point, you felt you went in the home and obtained your firearm. What were you thinking at that time?
I have to get my son safe. I didn't know. I just thought he was gonna kill me and my son and my father, and I didn't know. I didn't know what was gonna happen.
When you came back outside and you had this firearm, first of all, did you have a concealed weapon permit?
Yes, sir.
So had you taken self-defense classes before?
Yes, sir.
When you came out, did you have any additional words or anything was said by you at that time?
Yes.
What was that, if anything?
I said, "Can you please leave? Why are you here? Can you please leave? What are you here for?"
And what was the response that you got?
He didn't say anything. He was just staring at me.
And then at some point, you felt the need to discharge your weapon. How many shots did you take?
One. I saw him. I was saying, "Why are you here? You need to leave. You need to leave. You need to leave. Why are you here?"
How were you saying it? Were you saying it softly, or how did you say it?
Like, why are you here? What are you here for?
Were you talking to him?
I don't know.
Could he hear you?
Yes,
How do you know he could hear you?
because he was staring at me, and it wasn't far. It's like from here to the end of the courtroom. Like, it wasn't far.
When you came out the house, or at the time when you took a shot?
I mean, I was in my driveway the whole time.
Bill Clinton, Mookie, I didn't in hell.
Did Mr. Payne appear to reach for something? Or
Yes. When I was saying, "Why are you here? You need to leave. You need to leave. Why are you here?" I seen him going like this, putting his hand up, like he's raising a gun towards me. And I shot one time, and I called the police, and I put my son in the house.
before we get to that point, at some point, you stated when you went in the house and came back out that his vehicle was.
So hold on, why did you go in the house anyway and come back out with a gun in your hand? If your son, I mean, you know, and not tell your son to go in the house, why you didn't put him in the house at first? Or did you shoot him to get your son? Like, was he hitting in his custody or something?
Even closer than it was at first when you first encountered him. Is that true? Is that a yes?
Yes, sir.
So after the fire, after you discharged your weapon, you called 911? I need you to speak into the microphone.
Yes, sir.
Did you remain at the scene?
Yes, sir.
Did you cooperate with law enforcement?
Yes, I did.
Did you provide a statement to law enforcement?
Yes, I did.
Even after they give you Miranda warnings, you gave a statement, right?
I was never read any Miranda rights.
You provided a statement, right?
Yes, I did.
Look, you hear the way he framed that. He said, "I was never read any Miranda rights." The prosecution gonna try to tear him up on that. I was never read any Miranda rights.
Is there anything else you want the jury to know that you hadn't said?
You know, before I got up here, I thought I knew what to say exactly. You know, but I don't. It's just no.
I don't think I asked you this, but at that time, how old was your father?
60, 62.
And how old was your son at that time?
8, 9.
How old? I'm sorry.
8 or 9, 8.
Were you intoxicated?
No.
No, I wasn't intoxicated.
With the police for 13 hours.
And all?
Then he gonna slide in at least for 13 hours.
Officers assumed or speculated that you were intoxicated?
No.
Now, at the scene of this incident, Tara Walker was present, right?
Yes, sir. Afterwards.
Did you see her go into the vehicle that Mr. Payne was in?
While I was on the phone with the police, I put my son in the house. I'm on the phone with the police. And I saw my father go over to Mr. Payne to see if everything was okay. And I can hear him telling her, find a piece of plastic so I could try to stop the bleeding. And I see her go through the back seat. She goes through both of the back seats. She goes through the front seat. She goes to the glove compartment, and she just runs. She runs to the other side, and we didn't see Tara until the police arrived.
Do you know, or did you see anyone else that may have had any relationship or affiliation with Tara Walker arriving on the scene?
Yeah, her brother and her father came, and I was just so confused because they had my son and my father and me like chambered away, and she's just frolicking around, calling her friends and calling her family.
Sustained.
You know, and I was just confused.
Mr. Doherty, I'm going to ask you this question. Did you see a firearm in the hand or in the possession of Mr.
Yes.
Hold on, we get right back
Now,
to that.
after
1 second. I want to see this video of the incident real quick because I haven't seen it, and then we get right back to that. It's not that much more left of it.
the defendant shot Mr. Payne, what happened from there?
I turned around to run towards Adrian or, get to him. His dad grabbed me and spun me around and told me that I needed to run.
It's It's not offered for the truth of the matter asserted, it's direct.
We're not going to have the arguments in front of the jury either, so let's come on up.
Heck no. She said that his dad told me I need to run.
Spun me around and told me I needed to run, to grab Havian and run.
Did you do that?
I did. I ran over I walked over, I tried to run, my legs felt like bricks. I went to him, I opened the car door, he jumped into my arms. He was already crying. I put him down because I couldn't carry him, and I told him to run. So we started to run. Larry ran over to Adrian.
Okay. Now, let me stop you there. So, you run after this, and have you shooting?
I just want to see the incident. We'll get back to her testimony later, another time.
Now.
Oh, here you go. My bad for the sound. Oh. Well, damn. She didn't sound like she was on his side. It sounded like she was scared of him. It sounded like he might have been wilding. And the dad said run. He might have been saying run from the son. Not the police. I thought he was talking about the police.
My son and my father.
No further questions.
Cross.
He said he ran up.
Good afternoon, Mr. Doherty.
Popped his ass.
Mr. Smith.
So, I want to go back to several things that you said in your direct testimony, but first I want to start out with, you said in your direct examination testimony that you gave a statement to law enforcement after this, right? Is that correct?
Yes, sir.
Okay. And you say in your testimony to this jury that you were never read your Miranda rights. Is that right? That's what you just said to your attorney?
From what I can recall.
Well, you didn't say you didn't recall, right? What you said to your attorney was that you were never read your Miranda rights. Is that right?
Yes, I did.
Okay. I'm going to direct you to page 12 of the transcript of your statement that you, with the detective in this case, beginning at line 5.
Really quick, can I say something?
I'm going to approach and I'm going to show you what I'm talking about.
Okay.
I've got to lay this for the record.
Okay.
I'm going to show your attorney.
Can I say something real quick? Hell no, you can't say nothing. What you talking about? I ain't asked you a question yet.
I'm going to let you read along. So this is where I read from, but I'm going to read it. So
This is the interview?
Yes, this is the interview.
Okay. I was in response. I was talking about when they initially arrived to my home.
Okay. But just
Not
to be
this.
clear, what this says is, okay, well, let me do this. I want to read your rights, okay? And you say, home. And the detective says, and then we can talk about that after, okay? And you say, okay, buddy. And then detective says, so you have the right to remain silent. You say, hum. And then anything you say can be used against you as evidence. Yes, sir. You're entitled to talk to an attorney now and have him present now or anytime during question. Do you understand?
What's with the unhums though? What's that? What's his name? Elvis Presley. What's with that Elvis Presley unhums?
And yes, sir. if you cannot afford an attorney, you can be provided with one without cost. Do you understand your rights? And then you said, after being read that, in the transcript of your interview with the detective, yes, sir. So you were read your Miranda rights, correct?
Yes, I was not read them initially when I was placed in handcuffs, which I was referencing to.
Okay.
Not my interview.
Your testimony to this jury not 10 minutes ago is that you were never read your Miranda rights. Is that correct? Never. That's what you said. That's not true, is it?
I was read my Miranda rights in the interview room.
Okay. Thank you. Now, another thing that you just said that I found to be interesting is you said that when you came back out of your house, after you'd gone in the house and armed yourself with a firearm, you said that you came back out and you said, "Can you please leave?" And you were speaking sort of calmly to the jury in a sort of meek tone that you're speaking today. Can you please leave? And this is after you came back out, after you armed yourself with a firearm, you're asking him, "Can you please leave?" Is that right?
Correct.
Okay. So I want to direct you. I'll let you look at it. I'm going to read it again. I'm going to tell your attorney to, this is your interview with Detective Gilberti. This is on page 50, beginning at line 16. This is going to be line 16 through line 23. Permission to approach.
You may.
I'll let you look at this and then I'm going to read it out loud because this is the opposite of what you just said. Starting at line 16, I'll give you a moment to read through line 23. All right, so your testimony on direct examination was that you were just asking him to please leave when you came out with the firearm, right?
Correct.
Okay. But what you said to the detective in your interview was, and I'll begin on line 16, detective, like when you came back out with the gun and he was still in his car.
Best evidence, Your Honor.
I don't recall. Don't
This
be
is
asking
impeachment?
me about no co-defendants. I don't recall.
Like when you came back out with the gun and he was still in his car, did he say anything to you? No. Well, sorry, Mr. Doherty, your response was no. The detective says, was there any communication? And Mr. Doherty, your response was, I didn't communicate with him, I shot him. That's what you told law enforcement the day that this happened in your interview, right? You didn't say, could you please leave? You just shot him. Is that right?
That's what I had said in the interview.
Right. Okay. So I want to go back a little bit. This afternoon, the afternoon going into the early morning that this shooting happened, you were at your father's house, right?
Correct.
And you had been drinking at your father's house?
Earlier that day.
And you had been drinking some shots of Casamigos at one point in the afternoon, right?
13 to 16 hours ago, that was 13 to 16 hours ago. The Casamigos, had me on, but, that was a while ago.
Earlier that day.
Okay, but earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Overruled.
Earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Okay. And to be clear, where was your vehicle
To be clear, is Casamigos for the Fricos?
when you came back to your house?
Parked in my driveway.
Okay. And so your father drove you to your residence from his house, right?
Correct.
But it's a close distance, right?
Yeah, I could have walked.
Okay. All right. So I want to talk about some other things that you said in your direct testimony. You were very clear in your testimony 5-10 minutes ago when your attorney asked you, did you see a firearm, right? You said, yes, I saw a firearm. That was your testimony 10 minutes ago, right? Correct?
Correct.
Okay. Now, I want to take you again to your interview with the detective in this case. This time I'm going to direct you to page 35 of the transcript of the interview. Now, on page 35, do you have the transcript, or do you need to see it?
I have a copy of it, but I don't know exactly.
Sure. I'm on 35 at line 25 and 36 at line 3. Take honestly say to this jury.
Objection, Your Honor. Objection, Your Honor. Argumentative.
And that's your answer. So you cannot definitively say and honestly say to this jury.
Objection, Your Honor. Objection, Your Honor. Argumentative.
Sustained.
You cannot say definitively that you saw a gun, can you?
Objection, Your Honor. Same objection. Argumentative.
Sustained.
Judge, can we approach?
Come on.
Was that cop that we was watching the whole first portion of the show, can he definitely say he saw a gun? Or it's a different standard, right? That's what she said. You don't actually have to see a gun. You just have to think there's a gun. We just seen them go through that whole thing, and she's sitting there. They don't have to think. They don't have to know there's a gun. You don't have to see a gun. You just gotta think there's a gun. Just imagine a gun.
So today in your testimony, you mentioned that you saw a shiny object when you first approached the victim's vehicle, right?
Yes.
Is that correct?
Correct.
Okay. But you never said anything at all in your initial interview with law enforcement about seeing this.
Objection, improper impeachment.
Objection, Your Honor. Objection, Your Honor.
You never said anything at all about the shiny object then, right?
When
When you had your interview with law enforcement at the interview room.
I had been waiting and sitting in the back of a police car for 7-8 hours. I was in the interview room for 6-7 hours. I hadn't slept. I was beyond tired, and my recollection of what happened could have been maybe, you know, I don't.
Okay, so you didn't say it then, but you're saying it now, right?
I said it.
Now, you mentioned in your direct testimony that you were concerned for your son and for your father who were present at the time of the shooting, right? Is that yes?
Yes, sir.
Okay.
I apologize.
But even by your own telling, there was never any threat by the victim made to your son, right?
Objection, argumentative, Your Honor.
Overruled.
There was never any threat made by the victim to your son, right?
Correct.
Is that correct?
I said correct.
And there was never any threat made by the victim to your father, right?
Correct. It doesn't have to be made to them, though.
Okay. Now, you would also agree that where the victim was parked.
He said it don't have to be. Just if I feel you threatened, if I think he might be in the threat, and then you in the wrong. That's right. That's the same thing y'all do, right?
Was not your property, right?
The neighborhood is considered my property. I don't own the neighborhood, but it's my dwelling. That's where I live.
Okay. But to be clear, Mr. Payne never set foot in your house, right?
No.
He never stepped foot on that piece of grass in front of your house.
He may have.
Okay. Do you remember a previous testimony in a hearing? In a courtroom like this?
Yes.
Okay. I am going to direct and show opposing counsel transcript of a previous hearing.
I don't know what he did when I went in the house.
Okay, I'll direct a question to you in a moment. I'm showing opposing counsel the transcript, page 156.
I don't supposed to be here. I don't recall none of that. All I recall is going back
Okay,
to
so, my question was, at the time, was that area that he parked, is that your property?
No, sir.
Okay, so you're saying it was not your property. You agree?
It wasn't my, I don't own the land. I don't own it. I was a tenant there.
I understand that. But you leased the property, presumably?
Yes, sir.
Okay. And with that lease, it doesn't entitle you to the entire neighborhood, correct?
It's a private neighborhood.
It's a private, is there a gate to get in?
There was until it was destroyed.
Okay, so at the time of this, you could just drive into the neighborhood, correct?
Yes, you could.
Okay.
It's still a private residence.
And that area that the victim was parked, that's not included in your lease, correct?
Correct.
Now, when you went inside your home to arm yourself with a firearm, in this case, the victim didn't follow you, right?
No.
He stayed by his car.
Correct.
And so you went in, you would have had time at that point to call 911 if you deemed it necessary?
Correct.
But you didn't do that, did you? Did you?
I didn't think it was
supposed to be
necessary.
here. I don't recall none of that. All I recall is going back to prison.
At that moment.
What you deemed was necessary was to get your firearm, to go outside, and to kill it, right?
No.
But that's what you did.
It's not subsequently what happened.
So you went in the house, right?
Correct.
You armed yourself with a firearm.
Correct.
You went back outside the house.
Correct.
You aimed. Before you shot, you aimed. Yes?
Correct.
And then you shot Adrian Payne.
After I asked him to leave several times.
And again, we already went through your original transcript, but what you previously said was you didn't communicate with him, you shot him.
You have
right?
audio recording of it.
Okay. I'm asking the questions here. You said, in what we've already established in your previous transcript, you didn't communicate with him, you shot him, correct?
If you say so.
I mean, we can look at it again. Do you need to look at it?
No, I looked at it already. You already showed me.
Okay, so you would agree. You said you did not communicate with him, you shot him, right?
Correct.
All right, I don't have any other questions. Thank you.
Redirect.
Yes, briefly, Your Honor.
Got him! Got him!
Could give him Miranda warnings. At the time when I asked you, had you been given Miranda warnings, is it your testimony that you thought when you were first encountering law enforcement, they never asked you a question as far as Miranda?
Correct.
But at some point throughout the time that you were in custody, you were at some point in the interview provided with Miranda warnings?
Yes, and I feel like, he tried to trick me with that question, which is how the answer came out like that.
And again, you've seen a video of outside, right?
Correct.
Could you hear the verbal altercation that you had with Mr. Payne?
Yes.
So you did testimony of Ms. Tara Walker too today, right?
Correct.
She also testified that you asked, why are you here, right?
Correct.
So you did communicate.
Correct.
Is it that you was probably confused when law enforcement was questioning you, possibly?
Yes.
Okay.
I was beyond exhausted. I was tired. I could barely keep my eyes open. It was like 10 o'clock the next day. I hadn't slept.
And again, that interview was recorded, right?
Correct.
Video recorded?
Yes, sir.
Okay. No further questions, Your Honor.
Justified and necessary in the circumstance, and it wasn't. While he carried the statement himself, the story is rebutted by the evidence that was already.
The state has failed to meet its burden under the applicable standard.
All right, we're just going to play a little bit of this argument, and that's going to be it. I think it's about 5 minutes or so. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. We almost up out of here. Shout out to y'all for hanging out with your boy. Much love.
Law. Case law president.
Well,
Therefore,
isn't this a nice surprise?
Judge, I think there's a misconception. Obviously, just because the defendant testified doesn't mean that I have to then put on a rebuttal case, which is sort of what it sounded like opposing counsel was saying. Obviously, the defendant's story is rebutted by the evidence that was already placed on by the state, particularly Tara Walker and the video that was presented into evidence where you can hear the encounter just before the shooting and the shooting itself. She stated that the defendant, came out and that he fired, not having been, there was no threats made in his direction, that the victim didn't have a weapon, there was no weapon found in the vehicle. All of this, a jury could find beyond a reasonable doubt that he did not act in self-defense. Further, by the defendant's own admissions in his statement, just because the defendant says it's self-defense doesn't mean it is. So while he characterized what he did on that day as self-defense, it certainly wasn't. If you look at the applicable law and the instructions that you're going to give the jury, that it has to be reasonable, and it's both an objective and a subjective standard. So the defendant himself has to reasonably believe that his actions were justified and necessary in the circumstance, and even if you found that that was met, objectively, a reasonably prudent and cautious person in the same or similar circumstances would have to feel the same. And his actions of going back in a house, arming himself, coming back and shooting somebody, that is not justified. That's not self-defense. So even if you just took his own words, he's not rebut the state's case that he was not acting in self-defense in this circumstance. I would point to, obviously, just going to the other point regarding the JOA, that I'd point to Mackey versus State. It's a first district case, 277 Southern 3rd, 762. I say it's a depraved mind, regardless of human life, second-degree murder may be established by competent substantial evidence that the defendant acted with ill will, hate, and spite, and that the circumstances surrounding the fatal act can prove the ill will, hate, or spite. In this case, you have the circumstances around it that show it. You don't have to have an express testimony or express statement that there was malice or evil intent, spite. You can look at the circumstances, as we have here, and we can clearly see that this defendant was not acting in self-defense. So I ask that you deny the JOA.
The absence of evidence is not the evidence of absence.
Yeah, we heard it all before. Let me get a state one more before we get up out of here. If it shows.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
Shout out to Joni Ford, today's stream sponsor. Chant My Black is Golden, always a stream sponsor. Shout out to y'all, appreciate y'all for the support. Much love, much love. Y'all show them some love, drop them some coins. Shout out to Brown Sugar Babe, I see you in the chat. Appreciate you being here, family. Shout out to No One. Shout out to TSC in the building. What up, what up? Late Night Baking with Mookie in the building. What up, family? Joni Ford. Miss Chocolate got gifted a membership from Joni Ford. If you happen to hear this, then that came from Joni Ford. Show her some love. No One, watch the rise. Miss DB was in the building, falling asleep, but came back. I appreciate you, family. Appreciate you coming back and hanging out with us. Cha Diggy came through. Shout out to Cha Diggy. Y'all show her some love. Drop her some blue hearts in the chat. Let's see. That's look like about it for tonight. Miss DB. Let's see. Brown Sugar Babe. Allie was in the building. Shout out to Allie. I see Allie. Much love, much love. And other than that, family, I hope y'all have a great one. Oh, my mouth ain't even moving. Let me turn my mouth on. But y'all have a great one. And until next time, family, y'all stay fresh and stay blessed. Oh, also, I will be coming back streaming some more stuff. I got a lot of stuff recorded, like I said, a lot of stuff I'm working on, editing on, but, man, it's just, still got to deal with life at the same time, you feel me? New track from No One. Y'all go sub up. Got a new track out there. Late Night Baking with Mookie. I see you. Salute. Peace, love, and joy. Joni Ford, we up out of here. And like I said, until next time, stay fresh and stay blessed, family. Peace out.
Have a good night. Have a good night. Have a motherfucking good ass night.
He arose, never hated friend or foes, just a sub to art and not giving a fuck. chasing down my goals. I self-law am master, supernatural disaster, metaphysical reactions. I am the flesh, I am the God. No one got the lab on lockdown. Talking hot winters and cold summers. Black Force Ones when we slide in the streets. We all stay home at a club jumping. What up, cousin? I see you, fam. Throwing slime coins when I watch the trial. LEOs be capping, chatting action. Come and tap in the most interactive. I am the flesh. I am the God. I am the flesh. I am the God.
Lost paper leg gon' tap in. Gun flesh skin every rap in. If you like us, gon' get the lights up. You sub, you shall tell them pack in. From the left, right, front to the passenger side. It's right here, the premiere. How you know? Cause them boys broadcast to the live. Wanna talk about it? Hit the link right here. Slide coins up, got 100 bands. Montage, watch how the check. And the band made love to a bomber head. 2 bands do a dance like check. I'ma keep going till I'm motherfucking tired. You what? I'm motherfucking tired. Slide brothers out, could we rain down game? Like, what you mean? Just watch the rise. Watch the rise. Watch the rise. I am the flesh. I am the God. I am the flesh. I am the God. Flesh of the gods. I am the flesh. I am the God. I am the flesh.